because WhatsApp was so important, right? And so therefore, the point that the other thing is, that good. I took oath in 2002 and I entered Sri Lanka Law College in 1999. At that time, we did not know what WhatsApp was, and at that time, we did not know what internet was. We had mobile phones, that big size ones, Nokia one, right? But apart from that, we did not know there's something called internet, right? And there's something called WhatsApp and those type of things, or Facebook, right? We didn't know. So at that time, we did not want those as well. But now, can you imagine a day without social media, without apps like WhatsApp and other things? I don't think so, right? So therefore, I'm coming back to the lecture. What I'm saying is, when we want, because we need many things to live our life, right? But those things, the things that what we want will not come to you free. Okay, you have to get other parties' agreement to get things for you. Foods. Foods will not come to you free. You have to buy them from supermarket or any other places, right? And then you have to negotiate with them. Second one, let's say shelter, right? If your parents give you a shelter, that is fine. But for many of us, we'll have to find our own shelter. Then that will not be free. You have to find a way and you have to buy your shelter. Transportation, okay? Nobody will give you a car or any other transportation means free. You have to pay for this. Education. Now, in Sri Lanka, some of you are privileged with free education if you went to the law faculty, right? And so it's free education, right? Or the Peradeniya or Jaffna is free education. But even in Sri Lanka Law College also, you have to pay some money. Not a big amount, but you have to pay. And then private education institutions, right? And you have to pay a considerable amount of money as well. So therefore, those are not free. So you have to have education. You have to deal with other people. Now, what will happen when you want things from other parties that are not freely available to you? To get those things, what you need in your life, you have to have contacts. Okay. I'm not talking about contracts. I'm talking about contacts. Okay. CONTACT. Contact. Okay. You need to have contact. The problem is when you have contact with outsiders, that outsider will be very keen on his own interest. Okay. The outsider will be very keen on his own interest in contract. Right? He wants the best out of the contract. Right? At the same time, you will also very keen on your own interest. Now you can clearly see two different interests, right? And now they are coming to an agreement here. Okay, so this is you, this is the other party. Both parties have two different interests, right? When you say different interests, let's say education, let's say you want to do a master degree, right? And you want to pay the minimal payment. You want to pay, let's say you want to pay only 100,000 for your master's degree. That is your hope. If you can get this master degree for 100,000. Okay. So let's go. You go to an institution. Institution says that the master degree is 1 million. Now your plan is to have 100,000. The other party says that the degree is 1 million. Now you can clearly see two conflicting interests. Now somehow you have to meet in the middle and get what you want. So when you are meeting, right, we call it is an agreement. Okay, agreement. Okay, right? So we have to have contacts with other people. When you are having that contacts, the agreement comes into operation, right? If you want to keep that agreement legal, then you create contracts. Okay, then you create contracts. I hope you understand what I'm saying. What I'm saying is, when you want to deal with another party, it is very important that you are looking after your own interest. The other party will look after his interest. So when you want to have that contact to get what you want, there will be conflicts in between parties. Okay, right? And therefore, to avoid conflicts, we make contracts to keep things legal. Okay, the consequence of contract, what will be the consequence of contract? That the consequence is when one party does not perform his contractual obligation, the right term to be used, when one party breaches his contractual obligation, right, the other party will have legal remedies. Okay, this is what happens in contract law. This is why we want to keep things legal. Okay, for us to get things, we have contracts. For us to keep the contracts legal, we make them, we change those contracts to contracts. Okay, contracts and contracts. Okay, and then you may be thinking why we don't say this is an agreement. Sometimes you have seen sales agreement, right? The written agreement, sometimes you have seen written agreement, sales and purchase agreement, right? But there are also contracts. The problem with agreements is not all the agreements are legally binding. Okay, not all the agreements are legally binding, or in other words, those agreements do not have legal consequences. Classic example is your friend promises you that she will take you for a coffee tomorrow. That is all an agreement. Then you agree. Tomorrow comes and she will not take you for a coffee. So then if you are, I'm so sure you will not be happy, but you will not have legal remedies because it was just an agreement between two friends. Therefore, not all the agreements will become contracts. Okay, right? I hope you understand. So let's move on with slides, and I will explain one by one. I will touch only the basic parts of contract law because contract law is a very bulky area. I will not be able to cover everything, right? And I will not be able to explain everything because it's very limited time period that we have. I have already spent half an hour, right? And I have another 1 hour to cover this set of slides. So my plan is this. I will explain what a contract is, and then I will tell you how a contract can be formed. Why we have to worry whether contract had been formed or not? Because the first thing is when you have a dispute and when you go to court, right? The first defense the other party will take is they will try to claim there was no contract. It's very obvious. They will always say there was no contract. Yes, I signed, but there was no contract, right? So they will often do that. So therefore, whenever you want to rely on a contract, it is better that you first establish that there had been a proper contract or the contract had been formed. Okay, that is a very important thing. So after that, I'm going to talk about, so under that, I will talk about very important areas, right? There are 6 areas that we'll have to cover, but I'm going to cover only 3 areas because of time limit. Other 3 areas are also very important, but they are not complicated areas, very simple areas, other 3 areas that you are going to cover. And then the next area that I'm going to cover, the content of contract. Okay, the content. That means when you get a contract, you have so many things written in the contract. Now you can clearly see what you see on this screen as well. There are so many things written in the contract. Okay, so we call them clauses. Okay, in other words, the right term that we use, terms. Okay, there are different types of terms that you will find in a contract. So I'm going to tell you, we are going to analyze those different terms as well. For example, you will find an exclusion clause. or maybe a restraint clause. At the same time, you will find warranties and conditions or innominate terms, right? There are few, and also implied terms that have not been written in the contract, but that can be applicable to contract, right? So there are different terms that we will have to learn. I will explain that as well in very simple words with very limited insight. Okay. And then I'm going to cover the vitiating factors, factors which makes the contract void. Okay. Under that, we will cover misrepresentation and duress. Okay. And then we will cover another concept called frustration. That is also a very important concept, right? How a contract can become frustrated, right? I think in Sri Lanka, the term that we use is supervening impossibility, right? And that is frustration. And then I will cover damages. I will cover how a contract can be breached, the end of a contract, how the contract can end, and if a contract is breached, remedies for the innocent party. Okay, so I'm going to cover those areas. It's a vast area for us to cover, but I will go through them very quickly and very clearly, and for you to have a basic understanding. Now, the thing is, in my lecture, these lecture slides are mainly based on English law principles. Okay, I'm covering English law principles because English law and Sri Lankan law, they are almost similar. Okay, apart from the part of that consideration, because in English law we have consideration, right? In Sri Lankan law we have justa causa, right? And apart from that area, other areas are almost similar. Okay, apart from few Sri Lankan case law. So therefore, I'm going to cover this area with English law principles. If somebody wants to have a comparison with English law principles and UK principles, there are many books available I can recommend, right? And but the focus should be with English law today to cover this particular lecture. Okay. So let's start with contract. What is a contract? Okay. I took this definition from Professor Treatel, right? And he says, in simple terms, contract is an agreement which gives rights and obligations to parties that can be enforced or recognized by law. Okay. An agreement that gives rise, that gives rise to obligations, right, and rights that can be enforced or recognized by law. Okay. Now these are big words, so let's move on to a simple definition for this, right? So at the end of the day, first of all, I need to advise. I tell you something a little bit. I have very naughty cat here in my house, okay, and she is always troubling me. Now also, okay, don't do that. Okay, she's always troubling me. I'm going to warn you. So she will come onto your screen as well. Okay. Um, okay, right. So contract is a legally binding agreement, right? And which gives rights, which explain rights and obligations to parties, right? If that particular obligations are breached, okay, the innocent party can have remedies. Okay, innocent party can have remedies. Okay, right? So that is contract. Now, please hold on for a minute. Okay, now what is a contract? Contract is a legally binding agreement. Okay, so what is legally binding? Legally binding means if one party defaults, the innocent party, the other party, the innocent party can claim rights under the contract. That means when I say rights, that is to go to court and claim remedies. Okay, so this is a contract. In very simple terms. Okay, now all what you have to understand is, right, it is an agreement, right, and which gives rights to parties, right, to go to court if one party does not fulfill his obligation. Okay, that is a contract. There are mainly two different types of agreements that you can have, a contract that you can have. Okay, first one, bilateral contracts. Okay, that is a contract between two parties. Okay, so you enter into a contract with another party, that is a two-party specific, that is called bilateral contracts. Okay, second one, unilateral contracts. Okay, right? So unilateral contract means that one party makes an offer and then many party can accept and enter into contracts. Okay, you have bilateral offers and unilateral offers, or in other words, bilateral contracts and unilateral contracts. Okay, I'm so sure you remember the case of Carlyle versus Carbolic smoke ball case. Okay, that is the most important case in contract law. So I always advise my students to remember the facts of Carlyle case, because Carlyle case was beautiful, you know. And if you carefully consider what happened in Carlyle case, I know the smoke ball company lost the case, you know, in the appeal. The smoke ball company lost the case. But still, what I praise about this case is, you know, the courage that the smoke ball company lawyers had. Their lawyers fought really hard and they tried to defend themselves with various theories. Okay, all the theories was rejected, but they tried their best to defend their client. That's beautiful. Okay, so if we have time, we will talk about Carlyle case as well. I think you remember Mrs. Elizabeth Louisiana Carlyle, an old lady from Scotland, good 130 years ago, went to a pharmacy and bought a product called smoke balls. Okay, and that smoke ball was problematic, and there had been a court case, and we learned many theories of contract law based on that particular case. Imagine when Mrs. Elizabeth Luciana Carlyle went to that shop and purchased smoke ball, she would have never imagined, okay, after 130 years of this purchase, still people talk about her. And Scotland is far away from Sri Lanka, maybe 3,000 miles or 2,000 miles away from Sri Lanka. And we are also talking about every contract law session, contract law lecture, right? We talk about her. Not only us, even common law, any common law country, and they all are talking about Mrs. Carlyle. And the beauty is, even this Sunday evening today, when we have the World Cup final cricket match, we are still talking about her. This is the beauty of Mrs. Carlyle. Okay, so I'm so sure if you can remember, I'm so sure you are very familiar with the things of Carlyle. If you cannot remember, please read Carlyle case. It's a very important case for contract law. The other thing, now you all are law students, right? And many others in many other streams like accounting and business and other education streams, right? They also learn contract law. So those kids or those students, they remember this Carlyle case a lot because they have very limited amount of things to learn in law. So they remember this Carlyle case, like Solomon versus Solomon for company law, or Donny versus Stevens for tort law, right? So they remember this case. So therefore, you have to have a very good understanding on this. So please read Carlyle facts as well. So now I told you there are two different types of contracts, right? And bilateral contracts and unilateral contracts. I warned you about my cat, right? And I have to warn you about my neighbor's dog as well. he barks without any reason. You can hear probably, I'm so sorry about this disturbance, right? And that dog is crazy. Okay. And for a contract to be legally bound, right? So now, so first thing that I told you, when there's an issue under a contract, when the matter is referred to court, the guilty party, the party who has breached the contract, will try their best to convince the court that there was no contract. That's what they do normally do. So they will try their best to convince the court there was no contract, right? So therefore, you as the counsel for the innocent party, the lawyer for the innocent party, may require to establish that there had been a contract. Having said that, I think you are well known that contract can be formed in three different ways, right? You can have written contract, which is the best option, right? And also you can have oral contracts, no written, right? And also you can have contracts by conduct as well, by implication or conduct, okay, right? There are three ways that contract can be formed. Now, whatever the way that you choose to have your contract, these 6 ingredients should be satisfied to establish a contract. Okay, those 6 ingredients are offer, acceptance, intention to create legal relations, consideration, capacity, and legality. Okay, intention to create legal relations, considerations, capacity, and legality. I'm not going to talk about intention, capacity, and legality. Those are very straightforward things. There's nothing much complicated. But I will today talk about offer, acceptance, and consideration. Okay. And so you will have to give you some insight as to basic principles of these three areas. So what is an offer, right? So let's start with offer. Offer is an expression of willingness to enter into a contract. Okay. So you as the offerer, the person who makes the offer, right? You show your willingness to enter into a contract. You can do it in many different ways, right? You can tell them expressly, right? You can tell them that I like to enter into a contract, or you can send an email, or you can send a letter, or you can display items. I don't know. Displaying items may not be amounted as considered as offers, but sometimes your actions can be considered as offers as well. So there are many ways that you can make offers. Okay. So all what you have to understand is, right, there must be an offer. Okay, for a contract to be legally bound. Now think about how the practical application of that, right? So let's say that you want something, right? Let's say that you want to have education, you want to do an LLB degree, right? So let's say you pick one institution. Let's say this is an institution. Let's take a hypothetical name. Let's say the institution name is the law college, not the law college that what we know. Let's say it's a private law college, right? So you want to have LLB from that particular private law college. Okay. Now, if you want to have the LLB, if you want to get the education qualification, you have to go and tell them that I like to enroll in this program. Okay, you have to go and tell them that I like to enroll in a program. That is offer, right? That means someone has to initiate contract talking, right? The person who initiates contract talking, we called him offerer. Or the person who makes the offer is the offerer. Okay. It's like that when you like a girl and when you want to go out with that girl, right? One day there will be a day that you will have to ask her out. Just looking at her or just pressing the like button on her social media pages will not be sufficient. Okay. You have to make a move and you have to say that, would you like to go out with me, or would you like to go for a coffee with me? Right. So that is the initiation. For contract also, you have to have that initiation. Someone has to start. That is called offer. That other party offers. Okay. And then the person who makes the offer, we called him the offerer. The person who receives the offer, we called him the offeree. Okay. Now, why we have, as law students and as lawyers, why we'll have to worry about offers? Okay. The problem is sometimes there's no clear evidence to show that offer has been made, or there may be some confusion, or there may be some issues whether offer has been made. Okay, because of course now when the innocent party goes to court, an innocent party tries to establish a contract, the other party will say there was no offer. This is what happened in Carlisle versus Carbolic Smoke Ball case as well. They argued, the smoke ball company argued there was no offer, right? So therefore, first, to determine remedies for the innocent party under breach of contract, the first requirement that the court will have to have is to establish that there was a contract. How you can establish there was a contract? You need to find out these 6 ingredients are met, and the first ingredient is offer. Then the court will have to find out whether offer has been made. Okay. So how you can determine that there had been an offer? Okay. For that, there are some rules which are deriving from case law. Okay. What we know, offer can be expressed or implied. Okay. So you can clearly tell the other party, I would like to enter into a contract. Or it can be implied as well. You are saying that you are offering, you are just, with your conduct, you are implying that you are offering, but you don't say a single word. A classic example is for implied offer made by implication, right? Classic example, let's say that you go to a supermarket and you pick one Coca-Cola bottle and you are very tired, and the cashier also very tired, right? And you go to the cashier and you just show the Coca-Cola bottle, and she takes the Coca-Cola bottle and she scans it, and then she gives to you, and then you give your card and she tapped the card, and you are not waiting for the receipt and you walk away. Okay. And in that particular contract, you have not spoken a single word. Okay. Right. That is also a contract. That is a contract offer. That is so when you say that, when you show the bottle and give that bottle to other party to scan it, what you are doing is you are making an offer by conduct or implication. Okay, you are making an offer by conduct or implication. Okay, and then this offer can be specific or general. I told you, and we have bilateral offers and unilateral offers, right? So in bilateral offers, you can be specific. You are making this offer to one particular party. And in unilateral offers, right, you can make the offer to whole world or one specific group, right? So therefore, there are two different types of offers, bilateral offers and unilateral offers, okay? And then offer must be communicated. It's a very important role, okay? For the offer to be a valid offer, you have to communicate your offer to the other party. The other party must have received the offer as well. Okay. Other party must have received the offer as well. A classic case for this is Taylor versus Lade case. And please, whenever you have time, please Google or search and find the facts of this Taylor versus Lade case. Okay. And the fourth one is offer must be definite and not vague. Okay. Offer has to be very clear. If the offer is vague, the court will apply contra profferentum rule. I don't know if you can remember contra profferentum. That means that if the clause is vague, the court will define that clause against the party who wants to rely upon. Okay, contra profferentum rule, right? So if the offer is vague, the court will apply contra profferentum rule and define that offer the court will go against the offer because that offer is not clear. Okay, for that we also have few cases. I have mentioned 2 cases here, and in addition to that, white versus Bluet case also very important. I have not mentioned it unfortunately here, right? So an additional case called white versus Bluet case as well. Okay. And also, offer cannot impose unnecessary obligations to communicate non-acceptance. Okay. Now, let's say you are in my class. Okay. I'm teaching you and I'm meeting you every day. I can see you have very beautiful mobile phone. I want to buy it. Okay. I'm telling you, I'm going to buy, I want to buy your mobile phone for 500,000 rupees. If you don't want to sell it to me, you have to send me a registered post letter saying no. Otherwise, I will think, I will assume that you have accepted my offer. That is not a valid offer because I am imposing unnecessary obligations on the other party, right? To communicate non-acceptance. That is not valid. Okay. And then offer must be distinguished from mere request for info. Sorry, I mean mere distinguished from request for information. Okay, right? So if you're asking the price or if you're asking whether you want to sell it, that does not mean that you are offering. You are just asking for information, right? So therefore, offer must be distinguished from request for information. Okay. The last one is the most complicated, not complicated, the most applicable one. The offer has to be distinguished from invitation to trade. Okay, the offer has to be distinguished from invitation to trade. What is that? That means, right, uh, 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 invitation to trade and offer invitation to trade and offer are two different things. Okay. Offer means expressing your willingness to enter into a contract. That is offer, right? Invitation to trade means, right, you are inviting other parties to make offers. Okay. Classic examples, things on display, they are invitation to trade. And showing things on shop windows, they are invitation to trade. Auctions and advertisements, right? They are invitation to trades. Okay. So therefore, offer must be distinguished from invitation to trade. I mentioned advertisements. Normally, advertisements are invitation to trade. That comes from Partridge versus Crittenden case, right? However, if the advertisement carries a reward notification with clear instructions to accept, then that advertisement will become an offer. Okay, that comes from Carlisle versus Carbolic Smoke Bowl case. Okay, that's also very important. So I have given you the detail of, not details, the summary of Carlisle case. So this is the exact advertisement that the Smoke Bowl company published in Pall Mall magazine, right? And when you have time, please search and go through the facts of Carlisle case. It's a very interesting case and very pertinent topic as well for contract law. And so what happened in this case also I have mentioned, right? And in that particular case, there were 4 theories tested, right? First one, whether it was an offer or mere sales puff. The advertisement was an offer or mere sales puff, right? That was the first test. Second one, whether acceptance can be done by conduct rather than communicating, right? That was the second theory. Third one, intention, whether the smoke bowl company had the intentions to be legally bound. That was also defeated. And the fourth question that was raised by the smoke bowl company was whether there had been valid consideration. Okay, right? And all 4 facts were defeated by Mrs. Carlisle's side, right? and she won the case, right? But those and that particular 4 areas, the principles for those 4 areas are now they are deriving from this Carlisle case. That's why I said I love this Carlisle's in Carlisle case, the smoke ball companies lawyers, because they have made massive effort to win the case by considering different aspects of contract law to win the case. They were not successful, but that's okay. But they had given their best shot. That's what I also advise as a senior lawyer to you as well, right? Sometimes in your life, when you are practicing as a lawyer, you get good cases and you get bad cases as well. You never know. Sometimes with good cases, you will lose, right? With bad cases, you will win. Okay. And there may be cases which are very obvious that you will never win, right? In that case, also, my advice is to do your best. Try your best to do a justice for your client. Don't lie. Don't fabricate things. Based on the law, just do your best shot. Give your best shot. This is what the smoke ball company's lawyers have done in this case. Okay. And then I'm moving to the second ingredient for a contract to be legally bound, right? That is acceptance. Okay. So according to Professor Treetail again, he says acceptance is a final unqualified expression of assent to all the terms of an offer, right? And in simple terms, whenever you have an offer, if you want to accept the offer, you have to accept the offer as it is. Okay. You have to say yes to all the conditions that are coming along with the offer. If you doubt, or if you raise any concern about the offer, or if you want something additionally what have been suggested in the offer, that will not be a valid acceptance. That may become a counter offer, right? So therefore, you'll have to be very, very careful. Okay. So therefore, acceptance should be as the offer stands, right? So you can't do anything that change the nature of the offer. You just have to say yes to all the conditions of the offer. That is acceptance. Okay. And for acceptance also, there are some rules to have a valid acceptance. Okay. First one, when you make the acceptance, you should have offer in your mind for acceptance to be a valid acceptance. Okay, right? A classic example is, let's say you are seeing a post or a poster of a lost dog, right? Okay, it's other way around. Okay, let's say you have, let's say um, someone has put a notice saying lost dog, and he has said that he will give 10,000 rupees if the dog is safely returned. Okay. And while you are walking, and you see a dog wandering around, and you pick the dog, and then you can see the owners and details in the collar of the dog, right? And you haven't seen that poster, right, saying 10,000 rupees reward. Okay, you haven't seen that, but you are a good person. What you do, you take the dog to the owner and hands it over to him, and then probably the owner offers you a tea, and you enjoy the tea, and then you come out. Okay, right? Because owner knows that you did not know anything about the reward notification, right? And then once you come out, you see that particular reward notification. Okay. If you go back and ask for money from the dog's owner, right? The dog owner is not liable to pay you that money. Why? When you return the dog, that was the acceptance, right? You did not have offer in your mind. Okay, you did not know anything about the offer, and as a good person, you return your dog, return their dog, right? So therefore, it's very important. The first theory is, when you are accepting, you need to have acceptance in your mind. Okay. And second thing, you have to accept as it stands. You can't bring any conditions. Okay. The acceptance has to be as it stands as well. So you can't bring any condition. If you bring any condition, it can be seen as a counter for or maybe a rejection as well. Okay. And then the third one is acceptance must be communicated. Okay, this is a bit of trick. This is a tricky part, right? Acceptance must be communicated. Now, for bilateral offer, right? For bilateral offers, a positive way of communication is required, right? And then acceptance must be reach the offerer, okay, to be a valid acceptance. That is the rule, okay? Acceptance must be reached the offerer for bilateral offers. But there's an exception for that rule. That is the postal rule, which comes from Adams versus Linsell case, okay? The postal rule, okay? And so just, I'm not going to explain the postal rule now because I personally don't like that rule I think that rule is crazy. Luckily that we don't use post much. We use it, but not very often. So therefore, that rule has become very not so important. But I advise you again to have a knowledge about postal rule as well, right? But for the moment, you have to remember in bilateral offers, you have to communicate your acceptance, and also the offerer must receive the acceptance to have a valid acceptance. Okay. And then in unilateral offers, right? Again, my cat is troubling me. Okay. In unilateral offers, right? You don't have to communicate your acceptance. You can complete the acceptance by conduct. Okay. You can complete the acceptance by conduct. Okay. That is what happened in Carlisle case. In Carlisle case, the smoke ball company argued if there was an offer, right, Mrs. Carlisle did not communicate her acceptance. Okay, that was the second argument for the smoke ball company. But the court said, right, in unilateral offers, there's no such requirement to communicate the acceptance. The offeree can complete the acceptance by performance. Okay, in Carlisle case, the performance was purchasing and using smoke balls by Mrs. Carlisle. That was her acceptance. Okay. And then the last requirement for acceptance is acceptance must be in the right mode. Okay. Acceptance must be in the right mode. Okay. That means if the offer says that the offer imposes some requirements to be satisfied with the acceptance, you have to satisfy that. For example, if the offer says that acceptance must be communicated in writing, oral communication will not be sufficient. If the offer says that acceptance must be made by a registered post letter, if you send your acceptance by a normal post, that will not be sufficient as well. Okay, so therefore, it's very important that these are the four main rules for acceptance. Then I'm going to move for consideration. For me, in contract law, in contracts, the most important part is consideration, because if you close your eyes and think for millions time, the only reason why we enter into contracts because we want to exchange consideration. Okay, we want to exchange consideration. Okay, right? That is the third third area that I'm going to focus on. Okay, consideration. Right. So what is consideration? Okay. I have very simple definition, and there are so many different definitions as well. And Professor Treetail and some from case law, and also in Justice Veeramantri, right, in Sri Lankan, he has written a law related to Sri Lankan contract law, right. There also he has given a definition for consideration. Okay, right. And so, what is consideration, right? In simple terms, in the formation of valid and binding contract, some things of worth or value that is either detriment incurred by the person making the promise or the benefit received by the other person. Okay, what is this? So many big words, right? So in simple terms, considerations are the things that we exchange in the contract. Okay, that's what I want you to remember. Okay, now when you write an answer in an exam, make sure that you use big words, right? But for you to have understanding, considerations are the things that we exchange in contract. Okay, and one golden rule that you have to remember here in Sri Lankan law, and English. So when it comes to Sri Lankan law differs from English law for this particular area. Okay, right? So in English law, for a considerations to be a valid consideration, that consideration should have some monetary value, some money value. Okay, but in Sri Lanka under justa causa, there's no such requirement that considerations to have money value. Even love, care, affections, those things can also be valid consideration. Okay, and also legal promise can be a valid consideration under Sri Lankan law. Okay, I learned contract law in 1999. Sri Lankan contract law. Okay. And by late Dr. W.D. Rodrigo, he died very recently, very respected person, former principal of Sri Lankan Law College, right? And he taught us contract law, right? Because that was my first year at Sri Lankan Law College. I learned Sri Lankan contract law. Now almost 27 years. Now I have forgotten Sri Lankan law principles because at my institution I teach English contract law, and therefore I have very limited knowledge about justa causa. But if you want to have a proper understanding, I advise you to read further. Maybe Justice Veeramantri's or Dr. Kure's book, right? Those are very important books for you to understand Sri Lankan concept when it comes to consideration. Okay, right? And so, as I mentioned earlier, consideration is something very considerations are the things that are very important to contract. The things that we exchange in contract, they are very important, right? And for me, the most important part of contract is exchanging consideration. This is the reason why we enter into contract. Okay, so the other party has something what we want, right? That is their consideration, and other party will not give you that thing to you for free. You have to give something to them as well. That is your consideration. Okay, this is how consideration works. Okay, right? When so there are two parties, right? And when one party makes a promise, and then the other party gives consideration. Okay, one party makes a promise, then based on that promise, the other party gives consideration. Okay, at the same time, this party also makes a promise, and then based on that, you give consideration. Okay, now when I say this one, I'm so sure you don't understand. Let me explain with an example. Okay, so I want to buy your mobile phone for 100,000 rupees. Okay, so this is you on the right hand side, this is me on the left hand side. I make a promise saying, I will pay you 100,000 rupees if you give me your mobile phone. Based on my promise, you give me your mobile phone. Okay. And then at the same time, you are also making a promise. He says, you say, right? If you give me 100,000 rupees, I'll give you my mobile phone. Based on that promise, I also give my 100,000. So therefore, consideration is having a pecking order. That is, promise first, consideration second. Okay, there must be a promise. Based on that promise, consideration is given. Okay, now this is the theory behind consideration. Now I told you both parties are giving consideration in English law. And also consideration should be something that has monetary value under English law. I'm telling you again, English law, okay? Consideration must be something which has monetary value. under English law, right? Let's say you are giving your mobile phone based on my promise. Okay, what will happen to you? You are losing your mobile phone from your custody. That is your detriment. Okay, that is your detriment or loss. You are losing your mobile phone when you give your consideration. At the same time, for your mobile phone, you are getting 100,000 rupees to your bank account or to your pocket, right? That is your benefits. Okay. So when you give your consideration, when you exchange consideration, you are suffering a loss and gaining a benefit. This is reciprocal. Okay, that works for both parties. At the same time, for me also, when I give my considerations to you, I'm losing 100,000 rupees from my bank account. That's my loss or detriment. At the same time, I'm getting your mobile phone to my custody. That is my benefits. Therefore, for consideration, at two different points, both parties would suffer losses, would gain benefits as well. If you can remember those, that is what I want you to have an understanding. And there are many theories under consideration, okay, which I'm not going to talk about at this moment, right? For example, for consideration, there are some rules, right? Consideration must not be in the past. Consideration should have monetary value. Consideration should not have exact value. There's no such requirement to have the exact value. That means that I can buy your mobile phone for 10 rupees also, as long as I have given you some monetary value. That is a valid consideration, right? And I mentioned consideration must not be in the past. For that, we have Remak-Ardle case, right? But there's an exception to that rule as well, that if the consideration had been given and the promise was subsequent, right? And if that consideration has been given with the understanding of that the party will be remunerated, and also that consideration was given at the request of the other party, even the past consideration can also be a valid consideration. That comes from Lampley versus Braithwaite case. Okay, right? Again, because I'm running out of time, and now 8:20, right? And so therefore, I'm going to cover the formation part for the moment, right? And so therefore, consideration means, right, that the things that we exchange in the contract, and then it should have monetary value, and there are some conditions, right? And there's no such requirement to have the exact value, and also consideration must not be in the past, right? And exception is Lampley versus Braithwaite rule, right? And then both parties at two different points would gain benefits and would suffer detriments as well. Okay. Now the problem is and then there's another rule. Consideration must be very clear and precise. If the consideration is ambiguous, then court may take decisions against the party that has made an ambiguous consideration. Okay, so those are the things that I want to emphasize. And I explain how it works and consideration, right? And then before I wind up, right? And what I have done so far, I told you whenever there's a dispute over contract, right? The first defense that the guilty party will take, the party who has breached the contract will take, there was no contract. So therefore, you will have to prove in the court that there had been a contract. Okay, very important. Okay, so for you to establish a contract, for you to establish that there had been a contract, there are some requirements. Those requirements are offer, acceptance, consideration, intention, capacity, and legality. You have to prove those 6 things, and then you have established a successful case when it comes to a contract saying there had been a contract, that is formation. Okay, right? Normally in an LLB program, you need at least 3 or 4 weeks to cover this area. Okay, I was trying to cover these things within 1.5 hours. Okay, And then before I wind up, I'm sorry, I will not be able to cover everything. I promised that I will cover the content of contract, including restraint of trade and and um, exclusion clauses. But because of time consideration, I will not be able to cover that part. And also, I wanted to cover misrepresentation, duress, and also frustration, right? Again, one day we will have another opportunity and I will cover that part. And if you want to have a understanding on that area as well, okay? And so one little thing before I end my presentation today, right? That is when it comes to breach, okay? What is breach? One party does not perform or fails to perform what he has agreed on the contract. Okay, that is called breach. Sometimes, if a party gives a defective performance, that can also be amounted to breach as well. Okay. Now, what I want you to understand, because in Sri Lankan context, we don't learn this anticipated breach a lot, right? There are two different types of breach. First one, actual breach. That means that the breach has already happened. Okay. Then you can go through the conventional method and you can sue the other party and claim remedies. And then there's something called anticipatory breach. That means you have been communicated by or informed by the other party that the other party will default or breach in a future day when the performance is due. Okay, that is called anticipatory breach. Okay, my kind request to everybody, right? We all know about breach, it's very straightforward. Please do some readings on anticipatory breach. It's something very different. Some theories are there. Okay. Mainly, Hoster versus De La Tour case is the most important case for anticipatory breach, right? Hoster versus De La Tour case. And then you have Whitehall versus Nolef case, right? So please read those cases as well. And then we have another two important cases, right? Um, that is uh, White and Carter versus McGregor. And then there's another case called Clear Shipping case. I can't remember the exact name. It's called Clear, CLEA shipping case. Okay. So please explore the law related to anticipatory breach as well. That's also a very important area because I can't remember the name of the case because there's a case that if you wait until actual breach happens, right, to go to court, sometimes the remedies may not be available. So therefore, as soon as that you learn that there will be a breach and the breach is very clear, it has been communicated, you will have to go to court. Okay. And so this White and Carter case was, which I don't like the decision, right? And that gives a different aspect to this anticipated breach, right? And that was corrected by clear shipping case. Please read those cases as well. Okay. And then finally, again, my cat. Finally, now my kind request to everybody, right? Contract law is very important and always read about contract law. There are some important areas which we know, which we don't know usually. Okay, those areas are right. We know misrepresentation, that's very straightforward. But there are two areas that you have to have good understanding. First one is restraint of trade. Okay, right? Restraint of trade or restraint clauses, right? And those clauses are not so new to us, we know, but under restraint of trade, restraint clauses, now we have exclusive service and trading agreements. There are so many developed law on that area. So please explore that area as well under exclusive service and trading agreement. And the next one is economic duress. Okay, very new area of English law, very important area, right? Economic duress is a very important, and because we were so relying on Sibato and was a Sibion case, and also Pao on Yulu Long case, but very recently, last year, okay, the English Supreme Court made a decision in time travels versus Pakistan airline case, right? And so that changed the entire nature of economic duress, right? And so please read those things. Those are very interesting areas. One day, if we have time, we can talk this one in details as well. And I'm sorry, I will not be able to cover everything. I have 5 minutes. If you have any questions, and if the organizers are permitting, I'm happy to answer any questions. Okay, I'm happy to answer.
Thank you very much, sir, for that insightful and enlightening session. We will now move on to the Q&A session. This is your opportunity to ask questions, seek clarification, and share your thoughts with our speaker. Please feel free to raise your hand or drop your questions in the chat.
It seems there's no questions, and I saw in the message box there was one statement by a student. Of course, I forgot to tell you Venezuela as well. I'm very upset with what happened in Venezuela. Okay, and very sad. And we learn law. Now, for me, I'm living with law for about 27 years, right? More than 30 years because with my law college time. And we always thought law can do justice and law can bring some sanity to the world, right? And um, um, that is very sad. Okay, right? And I can see another question. So of course, I agree with you, right? And Venezuela also very sad story. I was telling my student, that let's say mistakenly, Iran Air Force attacked a school in a girls' school in Israel, and around 150 schoolgirls died. What will the media say about that? They will say it's a terrorist attack. The West will say it's a terrorist attack, right? But now, when the Israel army attacks a school in Iran, that is a preemptive action for the Western media, right? As a precaution, as an action to self as action of self-defense. This is how the media sees. And also, I'm very disappointed with media as well, and BBC and CNN, other media, they are biased, right? Uh, Al Jazeera may be in the middle, but I can still see they are also be not very um, um, uh, particular about some areas. I think they are also scared. Probably they don't want to upset USA, right? But media are also very biased. Okay. Now, coming back to your questions, there was a question. Let me check that again. How to deal with antitrust law and exclusivity in contract law. Okay. Very good area, antitrust law. In Sri Lanka, we call antitrust law. And in Sri Lanka, we call it competition law. In the UK, also the term that we used is competition law for antitrust law, right? And in the European Union, there's a very good regime for antitrust law. And in the US, we use the term antitrust law. Okay, antitrust law is basically to protect unfair protect customers from unfair practices, right? In Sri Lanka, unfortunately, we do not have a developed system. And very recently, I was in a meeting and on this particular meeting with the Law Commission, and I think the President Council, Mr. Unambu, Neil Unambu, I think I can't remember his name exactly. And he's working on this to have a proper regime to Sri Lanka on antitrust law. Now, your question is antitrust law and exclusivity in contract. Okay. Exclusivity in contract and antitrust law, I don't see a connection between those two. Antitrust laws are there to protect consumers from unfair trading practices, because you know that sometimes the manufacturers and traders and even the companies can work in collusions and fix prices and use unfair trading practices to um, uh, exploit the vulnerability of consumers. Okay, right? But exclusive contract is for a different reason. Exclusive contract is when you want to enter into a contract with another party, right? Probably the other party will want exclusivity from you. A classic example is, I remember when I was doing my O levels in 1996, Sri Lanka won the World Cup, Cricket World Cup. At that time, Sanat Jayasuriya became the most valuable player. And I remember he entered into a very lucrative contract with Pepsi Cola. At that time, Pepsi Cola or Pepsi, right? That was around 30 million US dollars. The role was that the requirement was he had to promote Pepsi Cola for 2 years. You know, that was an exclusive contract that he has to make sure that his image is exclusively available only for um, um, uh, Pepsi Cola. Okay, those exclusive contracts are dealt with restraint of trade principles. Okay, and in English law there are so many developed areas, right? Areas to cover this particular exclusive contracts. But antitrust law, of course, even in the UK they have a very good regime. I'm not so much expert in antitrust law, right? And what I understand is because I remember we did a guest lecture from a professor from my university in the UK, right? Professor Gerard Conway. He did a session on European Union antitrust law to my students here in Sri Lanka sometimes back. I remember he was telling that antitrust law in the European Union is very advanced and very comprehensive. Hopefully, we will have also a good a regime for Sri Lanka as well. Now, as a conclusion for your answer, right? I think these are two different areas that is to be dealt with different laws, right? But of course, we can see some connections also, right? If you want to connect, right? But I believe those two should be handled in two different ways. I hope I satisfy your question. Yes, Srikantan.
Hello, could you hear me?
Yes, I can hear you.
Yes, hi, hi, a long time no see. So this is regarding contract law, but in the procedure side. Now this is for Sri Lankan jurisdiction. Now, usually if contracts, when they are made, they would have a dispute resolution clause, right? If there's a breach of contract or some sort of nullity, you would go to court or arbitration. Or as for we know in Sri Lanka, when such disputes arise, it either goes to the district court if the valuation is 2 million or 500,000 or if it goes to commercial high court with 50 million. Now, when the contract, when we sign upon it, if it doesn't have a dispute resolution, which approach would it go naturally? Will it go to courts naturally, or shall it go to a much smoother, like arbitration route, if there's no dispute resolution?
The thing is this, okay? Now, there are two aspects of this. Now, we know we can go for litigation. That's the very straightforward way. If there's any dispute, it doesn't have to be with contract or any means, right? And you can go to court and claim remedies. That is very important. But what I know, what I understand is if you want to go for an alternative method, there must have been an agreement within the contract saying that if there's a dispute, we will refer this matter to arbitration, mediation, or negotiation, or whatever the things. The thing is, that can be done even after dispute as well. But when you have a dispute, the relationship between parties may not be good. So at that point, to have an agreement on the method of dispute resolution may not be possible. So therefore, my advice is whenever you draft a contract, be particular about how you can develop, how you can resolve this dispute. Okay. Now, the other aspects of your question is, right, my advice is whenever it is possible, go for ADR. Okay. And because we know the court system, it takes time, it takes money, and justice will be very delayed, right? And also it can be very tiring as well. So therefore, we have alternative methods, right? We have arbitration, we have mediation, we have negotiation and conciliation, and there are different methods that you can know. You have MEDAB also, so MEDAB, mediation and arbitration together, right? So there are different things that you can consider, and you should go for those things. Again, the problem is, even in that arbitration, mediation, other things, those are also handled by Sri Lankan legal professionals who have been accustomed to litigation. So therefore, there may be delays again in arbitration and other means as well, right? And so therefore, but still, my advice is to go for ADR. When I say ADR, the best choice, what I can recommend is to go for mediation. Okay, because if you go for arbitration, what will happen at the end of the day? There will be a party who has won the arbitration. There will be a party who has lost the arbitration. That is not ideal in business context, because commercial normally contracts are made in business context, right? So that may not be ideal to parties to have their relationship without making damages. It's better to go for mediation, because in mediation there's no loser, there's no winner. It's a compromise between both parties that will make things better. Okay. Again, there are problems when the mediation award is made, the decision is made and the contract is made, right? And again, if there's no the way that you can enforce the contract, right? This is the problem that we have in Sri Lanka. So you go for mediation and you have an agreement and you make a contract based on that agreement under mediation. And then if the agreement is not followed by a party, then you may have to go to court against under that agreement. So that is not ideal as well. So therefore, the law has to be developed. But my advice is to go for ADR, right? And also to have that dispute resolution clause in the contract itself at the beginning, not after this dispute happened. The problem is, if you are going to have an agreement on dispute resolution after the dispute, then it will be very difficult for you to reach for an agreement. Parties will not be in good relationship, and then it will be very difficult for them to have an agreement. That's all.
Thank you, sir. Thank you, sir.
It seems no questions. I think we can wind up, Sugandhini, right?
Thank you to everyone who asked questions and took part in the discussion. And a very special thank you to Dr. Chathura Warnasuriya for answering them with such clarifying intent. We truly appreciate your valuable insight and the time you dedicated to us today. On behalf of the legal field community, I would also like to extend our sincere thanks to all the participants for joining us and contributing to the success of this session. We happy today's webinar added meaningful value to your academic and professional journey. Have a wonderful evening and thank you once again. Thank you so much, sir.